Good morning.
Morning.
Good morning. Hello, everybody. The time is 10 a.m. and the inquiry is open. My name is Owen Woodwards. I am a Chartered Town Planner and I've been appointed by the Secretary of State to hold this inquiry. I will just start with some housekeeping. Firstly, can everybody see and hear me?
Yep.
Yes, sir. I wondered, sir, whether or not it might be okay to just ask those people who aren't, when they're not addressing you, to ask people to mute themselves. Otherwise, it might, with this many people on the line, might get a little bit tricky.
Thank you very much, Mr. Simons. Yes. So, as everybody can see, we're using Zoom for this inquiry. And it would be beneficial if everybody mutes themselves when they're not speaking. If I could also ask everybody other than the advocates and Dr. Keefe, and of course myself, could turn off their videos unless they're actually participating. That would also help with bandwidth. That'd be very helpful. Thank you. But I would like the two advocates, Dr. Keefe, to keep their videos on at all times. Just because, of course, you're playing such an important part in the inquiry. Thank you. So in general, are people comfortable with Zoom and how to use it, and just in general, just operating the functionality of this system?
Yes.
Thank you. It does have a chat function, but I don't want to use that because that would perhaps start having side conversations, which is difficult to manage. So we won't be using the chat function. There is a hand raise function, which of course people can use, and I will take account of that. But I have found that that's not always necessary, and sometimes it just flows better if people just speak. I think that's the kind of thing which just regulates itself as people get used to the inquiry as it progresses. In terms of adjournments, when we have adjournments, I will leave the meeting entirely. I believe, though, that you can, if you wish, stay in the meeting. Obviously, if you do so, then any conversations you have would be overheard by other people, but it's completely at your discretion. Just so people are aware, as the inquiry progresses, I will at times be looking down like this, which is where I'm writing my notes, or over like this, where I'm looking at my second screen. So please don't think that means that I'm not listening to you. It will be I'm either making notes or looking at a second screen with some documents that I'll be reading. Yes, no, there's no issue when that's happening, and I'm still listening. The inquiry is being live streamed, so I believe that's the case. Just double check with the council, that's still the case. Thank you. Just letting everybody know that. In terms of Zoom technology, does anybody have any questions before I move on? Okay, thank you. I'll start with notification letters. So I've been provided with photographs and locations of the site notices, and also a notification letter and distribution list. So thank you to the council for that. So I'm just confirming that I've received all that information. Some background here. So we had a case management conference on the 6th of December, which was attended by the council, the appellants, and also Bottisham medical practice. This was a meeting held to discuss the procedure for the inquiry, and we did not discuss the merits of the appeal. But it helped to set out the scope and how we've set out and organised the inquiry, which we will be turning to now. But before we get into that detail, I'd like to start with appearances. I would like to take down the names of people who wish to speak at the inquiry. And I will start with the appellant and turn to Mr. Simons. Thank you.
Good morning, sir. Thank you. Excuse me. Can you hear and see me all right, sir?
Yes, you're a little bit quiet.
Right. I will try and sort that out. I'll do my appearances and then I'll have a look at my settings and try and sort that out.
It might be my issue, and it might be, we'll see when other people start speaking, it might be I to adjust my settings, but it's
I
okay.
can hear
I can hear you.
I can hear Mr. Simons loud and clear.
I'm very grateful
Okay.
for that, Keith.
It might be my, if you just give me a second, it might be
Sure,
my
sir. Yeah, of course.
side. Do you mind just saying something?
Of course, testing.
Thank you.
I'll have a look at my settings after this, sir, and see if it makes sure. But I'm glad that Dr. Keith can hear me anyway. That's a good start.
Okay. No, okay. I think I've sorted it my side. So
Good.
we're okay now. Thank you.
Grateful. So thanks a lot. So Zach Simons, I'm a barrister. I'm instructed by Phil Grant and Andrew Adams of Access Land Partnerships, who's the appellant. So as you'll see, I'll forward it on to the council and to to Dr. Keith in a few minutes when I start reading it out. But I've got an opening statement, and it's got on the front sheet of it a full list of everyone, my team, and all their qualifications. So you won't need to write all this down, sir. Hopefully it's coming to you via the case officer, but I'll just let everyone on the call know who they all are. So I've got 5 witnesses who I'll be calling. I think in this order. We'll come back to timetabling. The first one is Mr. Nick Sedgwick of Ben Cave Associates, who'll be dealing with healthcare benefits associated with the scheme. The second one is Ms. Jessamine Venables, who's a director at Carterwood, and she's produced evidence on the question of need. The third witness is Mr. Robert Belcher, who's a consultant at Carterwood, and he's produced evidence on the issue of alternative sites. The fourth witness, I say fourth because he was supposed to be going first, but as you'll know, sir, he'll now be coming on next week. The fourth witness is Mr. Charles Crawford, who is a director at LDA Design. And Mr. Crawford gives evidence on issues of character and appearance on the one hand, and also Greenbelt matters on the other. And then our fifth witness, who touches on just about everything, as is the planner's role in these things, is Mr. Ian Warner. He's a director at Tetlow King Planning, and he overall his evidence turns on planning policy and the overall planning balance. Thank you, sir.
Thank you very much, Mr. Simons. If I can now turn to Mr. Smythe for the council.
Morning, sir. I'm Jack Smythe, the barrister instructed by Maggie Camp, who's a solicitor for the District Council. I've got 2 witnesses, Anne James on planning and Robert Brown on landscape.
Thank you. And we also have Dr. Keith.
I'm Dr. Tamara Keith, and I am a partner at Bottisham Medical Practice, representing the views of all of the partners of Bottisham Medical Practice.
Thank you very much. Okay, thank you. So yes, no surprises there. That's everyone that I had listed ahead of the inquiry. So we have here, of course, the Bottisham Medical Practice, who are a Rule 6 party, primarily concerned with the healthcare aspects of the appeal. And then we have the council, who are primarily concerned with everything else. And we will, of course, be working through that during the course of the inquiry. Now, in terms of interested parties and persons, I have here noted down councillors Charlotte Kane, Nadine Cundall, John Ogborn and John Wilson as being registered to speak. Now, if you are all on the call, I'll just turn to you now just to see, firstly, if that's accurate. And secondly, if you are able to speak later on this morning following opening statements.
Yes, if I could speak on behalf of Parish Council, there's 3 parish councillors here. I think there'll only be one of us actually speaking on behalf of Parish Council this morning.
Thank you.
Can I just make a comment just in passing? I know I had a message from Mr. Robert Stocking, who is a resident who wanted to speak, but due to work commitments, was not able to speak today. Is it possible that we might be able to schedule another time for him to speak later in the week? Yes, almost certainly. We will make sure we can do that. If you could ask him to please email the email address that you all given to contact the planning inspector with some suggested times.
and we will accommodate him as best as we can. But yes, almost certainly. Thank you.
That's excellent.
John, I can take that in hand, sirs. I'm also have his statement provided. I believe John does too. So if he is unable, he has asked that we do convey that statement across, but we will find out times for him. Thank you very much, sirs. Thank you.
Dean, could you contact him then, please?
Yes, I will do.
Thanks
Yes.
so much. That's great.
Yeah. Thank you very much, sirs. Thank you.
I'm the ward councillor, and I would like to speak, but I similarly actually have work commitments today, so it would be significantly easier for me if I could speak tomorrow. But if not, I will speak today.
Would you be available at 9:30 at the start tomorrow?
Yes.
I think that probably makes sense, because then that would be the least disruptive to wherever we stand with other witnesses.
Thank you very much.
9:30 tomorrow. Thank you. And Councillor Wilson.
Yes, I'm happy to speak, but I'm Vice Chair of the Parish Council. John Ogborn is the Chair. We have agreed the form of words, so I'm happy to speak if Mr. Ogborn happens to be unavailable at the time.
Okay, well, perhaps we'll start then with Councillor Ogborn, and then we can take a view. You can take a view after that on whether you need to add anything further following his speech.
Okay,
thank you. And Councillor Cundall.
Again, I will leave comments all to John Ogborn to represent the council. I was here as a participant to support the councillors if they're unable to make it. And then also, as we've already stated, to put forward the comments from Robert Stocking if he's unable to join. But I will contact you and provide you, sir, Mr. Woodwards, with some times that Robert Stocking can perhaps make this.
Okay, thank you. And Mr. Jolly, have you got that name correct? You're raising your hand.
Yes, good morning. I'm a resident of Bottisham, and I have registered to speak, so I'm not quite sure where you'd want to include me in the proceedings.
Ideally following openings this morning. Are you available this morning, later on this morning?
I'm free after 12:30.
We'll have to see how we progress. It will depend where we stand. That might be difficult because we might be in the middle of hearing from a different council witness.
Okay, shall we play it by ear then?
Yes, although if it doesn't happen today, I would like to set a specific time for you to appear. So if it doesn't happen today, if you could email the planning inspectorate with your availability, please, so that we can program that in.
Okay.
I'm just trying to avoid disruption to other witnesses. So we accommodate as much as we can, but we also have to make sure that the flow of the inquiry isn't harmed. Okay, thank you. So I'm just making some notes. Is there anybody else who would like to speak? Okay, thank you. Are there any members of press? Thank you. Okay, so I'll now turn to the appeal itself. So it's been made by Access Land Partnerships Limited on behalf of Bottisham Farming Limited against East Cambridgeshire District Council. It relates to the refusal of outline planning permission with access in full and all other matters reserved. Reference 20/00296/OUM for development of retirement care village in Class C2 comprising housing with care, communal health, wellbeing, leisure facilities and C2 affordable dwellings. Up to 30% on-site provision, public open space, play provision, landscaping, car parking, access and associated development, dated the 5th of March last year. This is on a site behind 163-187 High Street in Bottisham. I'll just pause there to check that I've got that correct. Thank you. So the appeal site comprises 2 fields, broadly speaking, just outside the defined settlement envelope for Bottisham. It's proposed for an L-shaped parcel of land to be developed into the retirement care village and a smaller area of the site to be developed into affordable housing. Vehicular access is proposed from the High Street and pedestrian access from Rowan Close. And also extensive landscaping is proposed. Again, pausing, just obviously jump in if anything there jumps out as wrong. Thank you. So the whole of the site lies in the green belt. Part of it lies in Bottisham Conservation Area. There are some trees with a tree preservation order or TPO. There's a public right-of-way running outside the site on the western boundary. And there are a number of grade 2 listed buildings to the south of the appeal site. And of course, we'll be coming back to these things as relevant throughout the course of the inquiry. So we now have a drawing list for the appeal. There's only a few of them, so I'll actually list them out. I have them as reference 6658 001A, 002A, 003C, 004A, 005C, and then a proposed access arrangement plan 1903044001 revision B. And again, I'll pause just to see. I can see people nodding. Thank you. So in terms of documents, all documents and evidence should already have been provided. If any parties do intend to submit any further new evidence, then can you please tell me now? Thank you, shaking your heads, thank you. Now, one item I did want to just cover, the council submitted an updated annual monitoring report and housing delivery information. So I just wanted to check that the appellant has received this and is aware of all this information.
Yes, thank you.
Okay, thank you. I just wanted to cover that because it came in after the previous conference. So thank you for confirming that. We have an inquiry website. Can I check? Can everybody access that and use that?
Yes, sir.
Thank you. Now, it's likely that there will be documents to add during the course of the inquiry. So can I please just check that the council are comfortable with keeping the website updated daily? And I can see Mr. Smythe nodding. Thank you. I think what I'll seek to do at the end of each day, or maybe first thing each morning, is just to confirm that my notes of any new documents match with yours to make sure that everybody is comfortable with that. And we'll just keep that running throughout the inquiry. Thank you. Conditions. So draft condition schedule has been provided, so thank you for that. We had a roundtable session for conditions tabled towards the end of the inquiry. It's my standard practice to provide a track changed version of the draft condition schedule ahead of that, and then that acts as the kind of agenda for the roundtable session, which I normally provide the day before the roundtable, because sometimes comments come up during the course of the inquiry that I want to add. So I will be sending that through later on. Planning obligation. Can I just turn now to the parties just for an update on where we stand on the draft planning obligation, please?
Yes, so there's been lots of, as you'd expect, there's been lots of back and forth over the detail between, in particular, the local authority and us. And I think that work has been sort of effective or quite successful for the most part. The final points in respect of some off-site contributions are being discussed and agreed today, apparently, behind the scenes, which I won't be involved in, but I'll obviously update you when we get news, and Mr. Smythe will tell me if I'm wrong about that. And the intention then is to obviously to get something to you ASAP, but this week, so that you've got lots of time to think about it or to read it through, ask us any questions, and then obviously we'll go through it in detail at the session at the end of the inquiry.
Okay, thank you. Mr. Smythe, is that how you see it as well from the council side?
Yes.
Okay, Thank you. Yes, I think I will ask if that could be submitted by the end of the week, please, so that I do have time to review that ahead of the roundtable session.
Yes, sir. Yeah.
Okay, thank you. I can also confirm that I have received the compliance schedule and also supporting statement from Cambridgeshire County Council regarding education contributions. So thank you for that. If that needs to be updated in light of the final draft of the section 106, then if the council can just make sure that they do that, please, at the same time when that's submitted towards the end of the week. Thank you. We would, of course, allow some time after the end of the inquiry for a signed version of the obligation, because there may be changes that are suggested during the course of the roundtable session. At this stage, does the panel of the council have a rough understanding of how long they think they would need for engrossed versions?
I missed what you just said, so could you repeat that last?
Sorry, following the inquiry, we will need to have a final signed version of the.
Oh, sorry.
But obviously, we don't know what format it's going to take until after the roundtable session. So we normally allow a few days afterwards.
Exactly. So let me take some instructions on it. Obviously, we need the council to as well. Given that we've got the council to sign it and us to sign it as well. It might be that we end up asking for 14 days. But can I come back to you on it?
Yes, that's fine. Really, as long as we confirm that at the roundtable session on section 106. Within reason, what's most important for me is to have a date so everyone has something focused in their minds, and we can just agree that at that time. Thank you. Okay, just going through my notes here and my headings. So main issues. So as agreed during the case conference and on the basis of what I have read, I'm just going to summarize now what I believe the main issues to be. Firstly, whether any harm to the green belt by reason of inappropriateness and any other harm would be clearly outweighed by other considerations so as to amount to the very special circumstances required to justify the proposal. Secondly, the effect of the proposed development on the character and appearance of the area, in particular the character and setting of Bottisham village and the character and landscape of the surrounding countryside, and the effect of the proposal on local healthcare. We will also be discussing as part of this the overall planning balance, which thankfully for once doesn't include housing and land supply discussions.
It's a unique case.
So, thank you to East Cambridgeshire, firstly for doing the right thing and providing enough houses, and secondly for giving us a day back in an inquiry where we don't have to discuss housing land supply in such detail.
Quite right. Just one comment on that from us, sir, if
Yes.
we might. We're very happy with that list of issues, of course. But just to say that on our analysis of the case, if it helps you, it might divvy this up however you'd like. Your first issue, the one about do the benefits clearly outweigh the harms, which is the test at 148 of the framework, that is, when you referred at the end to the overall planning balance, on our case, that is the overall planning. I mean, that's benefits against harm. So for us, it might be that you could almost, if you wanted to, you could almost sort of combine those two headings, if you like, because really, if that's what it all comes down to, all the other things almost sort of feed one way or the other into that overall test. But anyway, how you it's all for you, sir, obviously.
Yes, absolutely. Yes, I think there's huge overlap there. I probably won't know exactly how I'll write it until I start writing it, and I'll see how it flows best. But the most important thing is that we discuss all the issues properly during the inquiry. Then I'll have the information I need.
Yes, sir.
So, thank you, Mr. Simons. One thing I thought I'd clarify it now rather than during the course of the relevant part of the inquiry. In the statement of common ground, there's paragraphs 5.32 to 5.34. If I just give you a moment just to bring that up, please, both the council and the appellants.
Yes, heritage, sir.
So yes, this is heritage. And the way it's written there concludes less than substantial harm to Bottisham House listed building and Bottisham conservation area. Then 5.33 concludes the public benefits outweigh the less than substantial harm. The 5.34, the way it's written suggests there's no adverse effects on heritage assets at all. which for me doesn't quite match 5.32, which says there is harm, but it's okay because the public benefits outweigh it.
Maybe so. This for the council really more than me, isn't it? Because it's the 5.34 is expressing the council's view. It might be that there's some sort of quite subtle distinction being drawn. If it was, it might be so subtle that I missed it, I must say, between on the one hand historic interest at 5.32 and 33, so i.e. historic significance, and then on the other hand character and amenities at 5.34. It might be that, as you say, that there's less than substantial harm overall to historic interest, but that the council doesn't think there's any adverse impact on character and amenities. But I'll leave it to obviously Mr. Smythe.
Okay, I mean, obviously, I don't necessarily expect an answer right now, Mr. Smythe, but if that's maybe something which you can, well, I can send to you now, but otherwise, just something to pick up at some point during the course of the inquiry with your witness questions. Thank you. Okay. Thank you for that. I'm going to come on to timescales and programme next, but before I do, is there any other comments that any parties have on the main issues? Okay, thank you. So it's scheduled to last for 7 days, and the programme was drafted on that basis for 4 days this week and then 3 days next week. As you have already been informed, my granddad passed away recently, and his funeral is next week on Thursday. So obviously we won't be able to have the inquiry on that day as programmed. I did ask if people could attend on the 4th of January instead. Now I understand the council and the appellant, that is okay, but it might be difficult for you, Dr. Keefe. So if I just turn to you now, just to understand your availability.
No, it's fine. I've rearranged things, so I'm available. Thank you.
Thank you very much, and I appreciate you rearranging things.
Not at all. My condolences to you. I'm sorry that you've got that happening.
That's okay. Thank you, everybody. So that makes that quite simple, really. We'll just simply shuffle everything forward by that 1 day. And I will conduct my site visit on the Monday of the week after, almost certainly. And again, I have space in my diary for that, so that should not be an issue.
So could I just check, have you sometimes inspectors have an opportunity, depending on what else they're up to actually have a walk around beforehand, unaccompanied? Have you visited the area yet at all with this site in mind, or will your site visit be your first go, as it were?
Yes, I've already been there. There was an atypically lovely day about 10 days ago, very sunny, so I decided to drive up and have a look. And I walked around looking from the public viewpoints, which are actually give quite a good understanding of the site with that footpath to the side, and also to the end of that, I can't remember the name of the road off the top of my head, but the housing estate road to the northwestern corner. So I have looked around, and I do have general understanding of the site.
That's very helpful. Thank you.
Thank you. So in terms of how it runs, we started at 10 o'clock today, but it'll be 9:30 for all subsequent days. We will be trying to finish. I mean, really, I think with virtual events, I think really the aim is more 4 o'clock rather than 5 o'clock, because people do get tired. And I try to run them with just 3 sessions a day rather than 4. But we will take a view, and it depends on how things are flowing and where the witnesses stand in their evidence cross-examination. But as a general rule of thumb, it's 2 1.5-hour sessions in the morning, and then a 1.5 to 2 hour one session in the afternoon. But we will take a view on that as we move forward. And of course, I'll seek advice from the advocates and Dr. Keefe to make sure that everyone's happy with how we take breaks. Mm-hmm. And of course, we have an hour for lunch every day as well. Okay. So structure and procedure, we'll be following the 2000 inquiry procedure rules. So in terms of structure, I sent out the draft programme, and I have now received some further information since I sent that from all parties about timings of witnesses. So thank you for that. Thank you as well to Dr. Keefe, who's been very proactive in updating some of her timings as things have come through. So I appreciate that. Thank you. Now, based on the information I've received, and the unavailability of Charles Crawford this week, I think what we're looking at is openings and interested persons today, subject to maybe some other interested persons later on in the week, as we just discussed just now. And then we'll probably get on to Anne James from the council for cross-examination, but that will bleed over to tomorrow.
Yeah.
And then we'd like to have Dr. Keith tomorrow as well.
Yeah.
And then we'll start with the appellant's witnesses in turn. We have character and appearance scheduled for first thing next week, just before the visual openness cross-examination.
Yeah. I wanted
to ask now if that was something we want to discuss, where that actually fits best.
Yeah, I've been thinking about that, sir, and rereading all the evidence. And I think I've discussed this a bit with Mr. Crawford, but my own view, and I know it was us who suggested it be done in the traditional way rather than round table greenbelt openness. But now seeing, if you like, what issues there actually are in dispute, there's quite a lot agreed actually on openness between the main parties. There are issues in dispute, but they are, I think, on analysis, pretty closely interwoven with and related to the issues on character and appearance. So it's the extent to which, for example, you know, any harm to openness will be perceived or whatever from local viewpoint, that sort of thing. And so on reflection, my suggestion is from on the appellant's behalf is actually, having set this hair running and about divvying up the evidence, actually that we consider recombining it into a single round table and having a single round table on next Tuesday that covers first character and appearance, if you like, traditional character and appearance, just character and appearance, landscape and visual. And then with all of that fresh in our minds, we have a session, or as part of that session, a topic on greenbelt openness. And I've got a feeling that that'll be a pretty efficient kind of way of doing it that'll avoid repetition, and all the issues will be absolutely fresh in your mind. And so hopefully that'll, you know, might actually end up saving us some time anyway. That was going to be my proposal.
Thank you. If I turn to the council, just to get their initial thoughts on that, please. Yes, happy with that, sir. Okay. So well, both main parties happy with that, then I see no issue with that. If you could both perhaps just give some thoughts whether you need to update the agenda. Yeah, in light of that. And we've got time because it's next week, of course. Yeah, will do. Thank you. I think what I'll do at the end of the day, because by then we'll have a better handle on how things are progressing as well, I will probably update the programme and have that sent around to you all, and then we can sort of agree that tomorrow. And hopefully during the course of the day, the interested parties that we spoke about this morning would have emailed us with their availability as well, and we can feed that into the programme. Would you mind, sir, if you're going to be doing that anyway, can I just give you one amendment to my timing? Yeah. I can't remember what the original suggestion was for Dr. Keith. My suggestion for Ms. James, I think, was up to, I hope it was up to 3 hours. Oh, yeah, I can see it was. Up to 3 hours is fine for Ms. James. But for Dr. Keith, I'm probably only going to end up having about 15 minutes. So it will be much quicker than the original estimate. So when you're rejigging it might be that we actually make more progress tomorrow than you'd originally anticipated, sort of thing. So I'll leave that with you. It might be that it means that we have I don't know, it depends on how long the council and Dr. Keith are with the witnesses, but hopefully it'll mean that we comfortably fit everything into this week that we have to do this week, and then have landscape, greenbelt and planning for next week. Okay, thank you. And Dr. Keith has also actually emailed me recently with slightly reduced timings for what he expects. So I think there should be some float in the programme. It's even vaguely possible we'll finish a day early. But I've said that before, and then actually that's not remotely happened when you get into the meat of the cross-examinations. So I think I would rather keep it on the assumption of 7 days, and we can always take a view as we move on about where we stand. Absolutely. So I mean, if push comes to shove, let's see how we go, because the one thing that we can't move from the appellant side of it, unfortunately, for the reasons that you understand, is Mr. Crawford. For his own reasons, he's got to be next week. And I know it would be a bit unusual, but if push came to shove, we could. Let's see how we get on. But the planning evidence, although it normally comes at the end, that doesn't have to be absolutely written in stone. And you know, if push came to shove, and we had time to fill, and we were twiddling our thumbs, Mr. Warner could be brought forward a bit. But shall we see let's take a view in a couple of days and see how as you've suggested, to see how the programme's going. Exactly. I think that makes most sense. And also, I don't like rushing closings anyway. because I like to give people time to write them properly.
Okay.
It might even be that we just have a slightly more relaxed approach to the end and a bit more time for closings. But as I say, we'll just keep that under review as we progress.
Thank you.
Thank you. Are there any other comments on the programme before I move on? Okay, thank you. So in terms of procedure, the roundtable sessions are led by myself, and then I invite the relevant representatives for each session to put their points to me, and I ask questions and parties ask questions of each other, but through me rather than in the style of cross-examination. Now, really, they're essentially hearings, mini hearings within the inquiry, and that's how they will progress. For the topics under cross-examination, we will hear from each witness with evidence in chief, then cross-examination, and then re-examination. Now, I generally ask my questions whenever they come to me, rather than keeping them all to the end. So I'll just interrupt and do that. Now, while covering this, Dr. Keith, I'm obviously conscious that you're not a planning professional, so probably not as used to this format as the other people here. So if you do at any point have any questions about how things are running and how things work, then please do not hesitate to ask. I think if anything, the council's witness will make everything become quite clear anyway, because the format that we use for the council's first witness will be the same for all following witnesses. So I think that will make things become much clearer for you if you do have any concerns. As I say, please do not, please shout if you have any questions on any aspect of this. And also to specifically answer the question that you asked, Dr. Keith, could you cross-examine the planning witness of the appellant? And yes, you can if you wish to do so. So we will allow you time to do that. And also in terms of the timings, we don't have to religiously stick to the timings. It's important that people stick approximately to the timings, but it's also important that I hear all the evidence I need to hear. And sometimes things just change during the course of cross-examination. Things take longer than you'd expect. And I would much rather that every issue that I think needs to be debated properly is debated properly, rather than people arbitrarily stopping because they think they've reached their allotted 45 minutes. So, and I think, again, particularly with yourself, because you're not used to this, I would completely understand if you slightly misread your predictions of timings compared to how long it actually takes. And we will just take a view on that as we go forward. So please, the most important thing is to get the information that we need, that I can make a robust decision.
Thank you very much.
So in terms of evidence in chief, the only other thing here is, so as you'll see with the other parties, they have an advocate and then a witness. So the evidence in chief, the advocate sort of asks them a few questions and the witness responds. Obviously, yourself, representing yourself. I've seen when people are giving evidence in chief in that way, I've seen it done. Often they'll just read out the elements of their proof that they think are most relevant. But really, it's up to you in how you want to do that and tackle that session. The purpose of it really is for you to highlight to me and to the inquiry what are the key elements that you wish to rely on. So as long as you just remember that, then that will be, hopefully that will help you in how you approach it. And again, it will make more sense once you've seen the council's witness go through their various stages of the cross-examination. Thank you. So yeah, slight visit. We sort of covered this already, but probably Monday the 7th. Now, I'm assuming at the moment this is unaccompanied. However, if anyone does want to accompany me on the site visit, can they let me know now, please?
For our part, so we're content, having heard the round table, that you can do it unaccompanied.
Yes, Mr. Jolly.
Yes, I live a matter of 50 metres away, so I'd be very happy to walk around the site with you.
Are there any specific things that you think would be gained from that? The reason I ask is because the site visit, if it takes place after the close of the inquiry, which is what is likely to be the case now, that there will be no opportunity really to have any discussion with me or raise any issues, because they have to be done through the course of the inquiry. What we do though, and this might be where you can make sure that you ensure that I look at what you want me to look at, is, or what I like to always do, is get a walking route prepared, which is agreed between the main parties and any interested parties like yourself beforehand. So essentially a map where I should walk, what I should look at, what are the key things for me to look at, which can be agreed during the course of the inquiry. And you could contribute to that. That might work better, sir.
Okay. Well, yes, that sounds fine. Perhaps if it's okay with you, when I'm submitting my comments, if you feel that what I've said would add anything to your visit, then I'd willingly do that. Otherwise, I'll leave it to your own discretion.
Okay, thank you very much, Mr. Jolly. Okay, so yes, so that's a like to be unaccompanied visit, and as I just said, I'd like a walking note to be finalised during the course of the inquiry, and we'll pick that up as we move along. Looking through my list here of things to cover. Costs. So no applications have been made yet, but I have allocated time at the end of the inquiry if any applications are to be made then. Just to note that the planning practice guidance does make it clear that if any are to be made, then they should be made in writing if at all possible. I will pause there to see if anyone.
No, there's none from the appellants.
Okay, thank you. I'd also just like to remind people that I do have the power to initiate an award of costs by myself, although hopefully I won't have to use it. Okay, does anybody have any comments in general regarding my opening remarks or anything else on the inquiry before we move on to the opening statements?
So, thank you very much.
Okay, so just so for the councillors in the background who are registered to speak, we're now looking at the three opening statements from the appellant, the council, and the Royal Six Party. We're then likely to have a break, and then hopefully after that we can come to yourselves. But I will, before we break, I will just ask you to confirm your availability at that point in terms of your appearances. Okay, thank you. So if I could turn to the appellant first, please. Thank you.
Thank you very much, sir. Can I just check? I've emailed my opening to Dr. Keith and to the local authority, to Miss James. But has it come through to you yet, sir, on your email? It has. Good.
It has.
Excellent. All righty. In that case, sir, I'll press on. Sir, the government tells us that meeting the need to provide housing for older people is critical, and that these needs should be met with a diverse range of accommodation choices, including what the planning practice guidance calls extra care or housing with care. This scheme's a far cry from traditional care homes. The retirement care village, which is proposed before you, involves self-contained extra care homes for private sale and for market rent, surrounded by a range of facilities, for example, coffee shop, cafe, restaurant, shop, variety of lounges and areas for social activity. It'll also incorporate a range of health and well-being facilities, and some examples include, spa, gym, treatment room, hairdressers and the like, all of that alongside CQC registered on-site domiciliary care provision available whenever residents need it. Now, as our team explains, a care village like this one offers residents a chance to downsize or right size from their previous home into private extra care housing within a purpose-designed community setting to better suit their needs as they age, in the knowledge that should their care requirements change, well, the home will not. Retirement care villages like this, already common in America and Australia, but still emerging in the UK, bring with them a massive range of benefits to the mental and physical health and well-being of their residents and to the wider community, including enormous financial savings to the NHS. Those benefits are recognised not only in national policy and guidance, but also in reams of academic and industry research into this form of specialist accommodation, as well as, of course, a long list of planning appeal decisions, and some of them you've got in the core documents before you. The spiralling need for this kind of accommodation isn't only national, it isn't only regional, it is a particular district-wide challenge in East Cambridgeshire. This district's population is rapidly ageing. The number of over 65s will increase by over 10,000 people by 2040, and the vast majority of those over 65s own their own home. And the point of that is it disqualifies them from, for example, affordable extra care. Even by 2025, so that's what, 3 years away, the gross need for private extra care accommodation in this district, and this is just for private extra care accommodation, is 418 homes. And to meet that need so far, this district has one scheme. One. And that's in Ely. So it's well outside the catchment area for Bottisham. How many sites then are allocated for private extra care in the council's local plan? 0. How many new schemes are coming through the development management process to provide private extra care in East Cambridgeshire, other than this scheme, of course? 0. So the need for this retirement village is profound. The council has no plans to address that need in a plan-led way. And as we've shown through the alternative sites assessment attached to the evidence of Mr. Belcher, there are no other sites to accommodate a retirement care village like this one in East Cambridgeshire, which are, number 1, suitable, number 2, available, and number 3, achievable. And to be clear, sir, the council, even now, today, has not identified any that meet those criteria, which is why the benefits associated with providing this kind of specialist accommodation for older people on this site are so important. Now, on top of those substantial benefits, this scheme will deliver critical and much needed affordable housing in a district which is not coming remotely close to meeting its needs, not remotely. The shortfall in delivery of affordable homes in East Cambridgeshire, even since the beginning of the plan period, is not in the tens of homes or the hundreds. It's a shortfall of over 1,200 affordable homes. And these are serious needs, of course, for some of the most vulnerable in our society. They are, as the Secretary of State has put it several times, real people in real need now. And their voices are not often heard in inquiries like this one. The position is unacceptable. The benefits associated with delivering a significant number of affordable homes in a sustainable location are very substantial indeed. Now, in addition to all of that, the scheme brings with it a range of important benefits identified in Mr. Warner's proof, including, of course, freeing up of family housing, provision of almost 9 acres of public open space, which is substantially above what's required for the benefit not only of our residents, but for the wider population of Bottisham. Biodiversity enhancements, very significant economic benefits flowing from a range of permanent new jobs and public facilities associated with the scheme. So, what then are the alleged harms? Well, the council's first point is that we are on the wrong side of the line, which is to say adjacent to but outside the settlement boundary of Bottisham. When on its own case, it's on the council's case, not ours, the local plan supports extra care to meet needs on the edge of settlement boundaries like this one, and the plan makes no provision for those needs to be met within settlement boundaries. Next, the council says that we, quote, encroach into what is deemed, quote, countryside, because, again, it's on the wrong side of the line. Well, you've seen it, sir. This site is a relatively flat, pleasant, but unremarkable field. It has no statutory or local landscape designations. It's not a valued landscape for the purposes of the NPPF, National Planning Policy Framework. As you'll see, and as you'll have seen, its visibility from the wider landscape is very limited still, because it is currently a field with nothing on it, the site would, in the language of the framework, be less open if this scheme were built. Because it's on the edge of a village, it would technically encroach into countryside. But in fact, as Mr. Crawford will tell you next week, the effects both on the local landscape and on the wider greenbelt are minor and will in any event only be perceived on the site itself and its immediate surroundings. So for all the many documents before you, sir, the question at the heart of this appeal is simple. Do the scheme's benefits clearly outweigh its harms? If they do, then national policy tells us to grant permission, applying the balance at 148 of the framework. And our case is simple. The benefits our scheme will deliver are very substantial. The need to deliver them is compelling. They clearly outweigh what will be localized harm to this site and its immediate surroundings. The balance at 148 of the framework tilts decisively in favour of granting permission. And for those reasons, sir, that will develop in our evidence and in closings, we'll ask you to allow the appeal. Thank you very much.
Thank you very much, Mr. Simons. And if I could now hear from the council with their opening statement, please.
Yes, so I hope both you and my learned friend have a copy.
Yes. So can I just take Dr. Keith, do you have copies of these as well?
I've got Mr. Simons, but I haven't got Mr. Smythe. I don't know if, because I sent my opening statement to Alison Bell this morning, I don't know if she's forwarded it on to the other parties or if you want me to do so now.
Alison Bell will do that. This is probably the only thing in terms of logistics, which I think becomes quite difficult with virtual compared to in person, is that sometimes when we're waiting for things to be forwarded by the planning inspector, it can take a while because our support staff aren't only working on this appeal and they're doing other things.
I'm happy to do so. I sort of had so many email addresses, I wasn't sure who's involved.
If you'd be able to, Dr. Keith, that would be great.
Yeah.
I'll do that right now.
Thank you.
That would be very helpful, thank you. But you probably will get a second copy at some point from the inspectors as well.
So by way of introduction, at the outset, it's helpful to record the large measure of agreement between the parties. It's common ground that the council can demonstrate a 5-year supply. The development plan is up to date and the proposal should be judged in accordance with it. That Growth 2, which sets out the locational strategy for the district, should be afforded full weight. The proposal represents inappropriate development in the Greenbelt, such that the onus lies with the appellant to demonstrate very special circumstances. And finally, there's a need for the form of development proposed. So in respect of the council's landscape objection, it's plain that the appellant's LVIA is seriously deficient. Mr. Brown's evidence draws attention to viewpoints representing sensitive receptors, which are not identified or even assessed by the appellant's evidence at application stage or by Mr. Crawford, and identify those listed there. These omissions undermine the objectivity of the appellant's LVIA. The council remains of the view that the appeal will give rise to significant harm to the character and appearance of the area, and proposed mitigation will have little effect in tempering the interruption to long distance views, particularly given the height of some of the buildings. So next, the appellant's alternative sites case. As the council made clear at the CMC, whilst it is its case that there is no need for this development to take place within the Greenbelt, it does not advance a positive case identifying specific sites which are suitable and available. It's the appellant's case that it has undertaken a thorough and comprehensive assessment of both the district and the wider market area, which demonstrates there is no other place to locate the appeal. That is a bold assertion, given that the Greenbelt only covers 3% of the district. It's noted that no alternative sites evidence was provided at application stage whatsoever. The very first time the council was provided with this evidence was in Mr. Belch's proof. Having scrutinised his evidence, the council is doubtful that the assessment is as thorough and comprehensive as the appellant suggests. Within an hour of the council's conference of council, that's me, on the 19th of January, Mrs. James sent an email seeking clarification from the appellant about the methodology used and querying sites in Ely and so on. No response to this request was received. This is unhelpful. The council is keen to narrow the issues in order to make the best use of inquiry time. It has been rebuffed. It's disappointing that the appellant has not engaged in accordance with the spirit of the instructions, sir, that you gave at the CMC. How reliable is the assessment? It's for the appellant to satisfy you that the methodology used is appropriate and cogent. Central to that is the filter deployed. The appellant has adopted a deliberately narrow filter. In particular, it applies a strict impermeable size filter of 3.5 to 7.5 hectares. This is not justified. Firstly, there's no evidence to justify such a narrow filter, save for the generic assertion that care village operators and developers typically require at least 3.5 hectares. Secondly, sir, Mr. Belcher has rejected out of hand any sites which are more than 7.5 hectares without considering whether the development can come forward there on part of the site. This is artificial. This is important as there is a number of sites in excess of 7.5 hectares, such as at Sowham, which should have been considered but were excluded. The requirement on the appellant to be entirely transparent and objective about the assessment is all the more important, given that everyone knows that it is the only one calling expert alternative sites evidence. The assessment would command more confidence had the appellant reached out to the council to try and agree the parameters of the search. Having considered Mr. Belcher's evidence, the council is doubtful that the methodology used is appropriate, or the assessment is either comprehensive or objective. The assessment contains significant omissions. For example, the site east of Clare House Stables in Dullingham. This site is referred to in Mr. Warner's evidence. It's 5.67 hectares in size. It lies outside the green belt. It has outline planning permission, which I recite there. Since planning permission was granted, no further applications have been submitted and the permission has not been commenced. In these circumstances, this permission lapses in about 2 weeks' time. Secondly, sir, the site at Station Gateway in Angel Drove in Ely. It's an allocation for up to 400 dwellings. It's 12.3 hectares in size. It lies in a growth area outside the Greenbelt. Pre-application advice has been provided for some of the site. However, the majority of the site is still vacant. So the council does not put forward either of these as an alternative site, but their existence casts doubt on the thoroughness and cogency of Mr. Belcher's assessment. And so I ask rhetorically, if Mr. Belcher omitted either of these sites, how many other sites have been missed? One is left with the distinct impression that the filter has been designed to be so discriminating so as to exclude a large number of sites which could and should have been considered. So if you were feeling cynical, you might think that the filter was designed to be so exacting to almost guarantee that the search fails. So penultimately, the conflict with the development plan. Given the site's location in the Greenbelt, there's a danger of losing focus on the fact that it's common ground the appeal offends policy growth 2, which should be given full weight. Directing the locational strategy of an area is the number one thing that any development plan does. It is a very, very important objective of any development plan. Growth 2 is not some incidental policy. It's one of the most important policies of the development plan. So you will see that there are 47 main policies together with the housing allocation policies and the employment allocation policies. Growth 2 stands at the top of the tree. Given that this policy goes to the heart of the spatial strategy of the local plan, common sense suggests that if the appeal is contrary to Growth 2, it is also contrary to the development plan as a whole. Setting settlement boundaries are an important component of Growth 2. The policy seeks to jealously protect countryside of this rural district out with the settlement boundaries, which do not fulfil the exceptions. That is how the council, reflecting the wishes of local people, has chosen to plan for the district. That is an expression of the government's imperative that the planning system should be genuinely plan-led. In arriving at this, the council has adopted a very important planning judgment, and in doing so, it has the full support of national policy. So in conclusion, the council submits the proposal does not represent sustainable development, and so in due course, you'll be invited to dismiss the appeal.
Thank you very much, Mr. Smythe. And then finally, Dr. Keith, if I could turn to you for your opening statement, please.
My name is Dr. Tamara Keith. I'm a GP partner at Bottisham Medical Practice, and I'm representing the views of all the partners at Bottisham Medical Practice. I qualified as a doctor from Imperial College London in 2008 and have worked at Bottisham Medical Practice since 2015, and personally complete 2 separate care home rounds per week. We have been accused of not engaging in the planning process. We are a very small practice and have spent over 100 hours preparing for this case, which is 100 hours I have not served patients. Over 200 patients will not have appointments with me in the coming week due to my attendance here, and 4 care home rounds will need to be completed by someone else. Bottisham Medical Practice strongly oppose the proposed development on the basis that it will overwhelm the primary care service provided by Bottisham Medical Practice. The applicant's characterisation of the development as a village is misleading. It is a residential care home in all aspects apart from tenure, apart from ownership within the accommodation in which the person lives. It is accommodation to house elderly residents and has on-site carers available. Thus, as a GP surgery, we have to plan for this in the same way as a registered care home. The applicant is applying for C2 status, defined as residential care homes, hospitals, nursing homes, boarding schools, residential colleges, and training centres. There is no differing planning class for retirement village. It is so similar to a residential care facility that there is no differentiation in planning status. The applicant is marketing the proposed development at NHS continuing care patients. Patients who qualify for NHS continuing care, by definition, have exceedingly high intensity care needs. These are patients who step down from hospital and do not step up from home. In my main evidence, I will describe various patients to illustrate the level of healthcare needs these patients require. The fact the developers are marketing this development at these types of residents provides significant evidence of the high care demands these residents will have and their impact on local healthcare services. There is no local demand for residential care home places or other elderly care facilities within Bottisham. There are 4 elderly care facilities in the local area, 3 nursing homes and 1 residential care home that at the time of writing all have ample vacancies. 1 in 4 beds were vacant at the time of collecting figures in November 2021. I accept these are not privately owned by the occupants, but they are elderly care accommodation, and the fact the vacancies are so numerous is of significant relevance, as illustrates Bottisham is already saturated with elderly care facilities. Having reviewed all the evidence, I remain unable to differentiate the level of healthcare need of extra care housing versus registered care homes. Both house elderly residents. Both have on-site 24-hour care available. There is no way to limit the numbers of residents with high-level care needs. The only difference is ownership of the building within which they live. Tenure has no impact on the healthcare requirements or impact on healthcare services within the community. Given the large vacancy rate currently in the catchment of Bottisham Medical Practice, using the November 2021 figures, there was 11% vacancies at Queen's Court, 42% at Hilton Park, 11% at Oaklands and 30% at Eden View, giving an average of 26%, more than 1 in 4 beds vacant across all elderly care housing in Bottisham, which illustrates there is ample availability of housing for the elderly with on-site care already, and no need for further provision. I have not therefore seen any evidence that there are very special circumstances for Greenbelt development to build an elderly care housing facility, given the 4 elderly care facilities already in Bottisham have such substantial vacancies. Bottisham already has too many elderly care housing places that generate excess workload for the medical practice. The developer states an area requires provision of accommodation for older people at a rate of 4% of the population of 75 and over. We have a population of 786 residents aged 75 years and over, 229 of whom are within specialist care. This gives a current rate of 29.1% in Bottisham. I have merged all our elderly care facilities together, as tenure of the property makes no difference to the healthcare requirements of the residents. Bottisham Medical Practice already has a significantly high percentage of care home residents compared to other local surgeries. The proposed development would take us to 7.86% of total patients in specialist elderly housing, compared to a current local rate of only 0.6%. Elderly residents generate a significantly higher workload than younger residents. Bottisham Medical Practice contains 4 existing elderly care facilities which allow us to predict the increased demand on our services from the proposed development. I have worked for Bottisham Medical Practice since 2015. I look after 2 care homes on a very regular basis, as I'm the lead GP for them, and visit the other 2 regularly as well. I have the qualifications and experience to understand the workload elderly residents place upon a GP surgery. The appellant has stated multiple times that the average age of the residents in this development will be around 80 years old. Increasing our elderly population of 75 years and over from 13.3% to a figure of 17% would create a disproportionate level of elderly residents in the village, and thus workload on the practice. I am not claiming that each resident requires a weekly visit. We do not provide that to any care home. My figures and predictions are based on what care we already provide to our over 75s age group. The fact they are all grouped together with on-site care does not make the job any easier for a GP surgery. From my experience of our elderly care home residents, they move from a vast geographic area as they move into the area to be near their relatives. They do not merely move to be near their previous residents. COVID-19 has demonstrated the dangers and severe risk of placing large numbers of elderly people together in close proximity in care facilities. The fact that the residents can self-isolate in their own household provides no protection when carers move from resident to resident. There may be an argument about funding. The increased demand will not be met by matched increased funding, which means that existing services will be cut and the proposed new development residents would be dangerously underserved and the safety of our current patients compromised. It is entirely possible that the addition of another elderly care facility within Bottisham would result in the closure of our list to new patients as a way of protecting the safety of our current patients and potentially the closure of the practice as a whole, as it would be unable to retain staff and no longer be viable. The appellant has helpfully reminded me that we have a low patient to GP ratio. This does not demonstrate spare capacity, but further illustrates my evidence that our current patient demographic is high demand and requires more GP time than the average surgery demographic. I repeat, our ratio of patient per GP does not represent spare capacity. It illustrates further our skewed local population and workload demand. Since the time of writing my evidence, we have had 2 GPs resign from post, partly due to stress of working in general practice and in care homes. One is now having a year out from general practice and one is moving abroad. They both have their last day a week today. We have not advertised for a permanent post for 6 years and have had 2 staff resign within a fortnight of each other. We have advertised nationally for the past 4 weeks and received only 3 applications, which is exceedingly low. This illustrates the challenge of GP recruitment and retention. The funding of primary care, while weighted by age, does not fully support the increased costs of older patients Bottisham already, as I've said, has an unusually high concentration of elderly residents, and this development will increase this further. The applicant is unable to make a credible commitment to additional regular funding for primary care, as they will be selling the development to an as yet unknown operator. There's been no effort from the appellant to honestly quantify the extra demand that this will place on the local healthcare facilities. Bottisham population is already skewed grossly towards the elderly, 13.3% of our population being 75 and over, compared to a local surgeries of 7.7%. Society relies on the planning process to ensure elderly care facilities are evenly distributed, so communities and GP surgery catchments are not overwhelmed. We have clearly set out our concerns and detailed data in all our evidence provided. The appellant has not modified their proposal to address any of our concerns. They simply assert that the care needs of the residents will be lower than we predict based on our extensive experience within this community. We have not seen any qualified medical advice from the appellant to support their assertions. We've not seen any evidence to back their assertions that the level of care required will be low or manageable. We can see no evidence of very special circumstances to allow development on the Greenbelt land. We are asking the planning inspector to uphold the current refusal in planning permission. Bottisham Medical Practice strongly oppose the proposed development on the basis it will overwhelm the primary care service provided by Bottisham Medical Practice. Thank you.
Thank you very much, Dr. Keith. Thank you. Okay, just looking at the provisional programme, I think we had a programme now, a short break, and then to come back with interested persons. Based on what we discussed this morning, that would be Councillor Ogborn and potentially Councillor Wilson afterwards, depending on what Councillor Ogborn had said. I'm sorry, Mr. Jurley, I can't remember now. Could you only speak from 12:30, or could you only speak up to 12:30? I can't remember now. If you're listening, that's direct question.
I'm sure he said after 12:30.
After 12:30. Okay. Looking at the time, if we had a break now, it came back around about 11:30 and then heard from Councillor Ogborn, that probably wouldn't really take us up until 12:30. So we might have to reschedule Mr. Jolie, unless we took an early lunch, but we can maybe take a view on that when we come back from lunch. The one thing I would just like to highlight, Mrs. James is currently programmed for this afternoon, but it looks like we might be going to do this a bit quicker and she might be able to do evidence in chief before lunch. If that's the case, are you prepared for that, Mr. Smythe?
Yes.
Okay, thank you. Is everybody comfortable with having a break now and coming back at 11:30? Okay, thank you very much. The inquiry is adjourned and will resume at 11:30. Thank you. Welcome back, everybody. The time is 11:30 and the inquiry is resumed. I can see Councillor Ogborn has his video on, so I think that's good news, and I think that brings that you're ready to speak, sir. So maybe perhaps I can turn to you now.
Yes, before I start, I would just like to say I had a brief discussion with Mr. Jolly. Sorry, Tony, you were a previous councillor. Tony's rearranged his programme, so he's available this afternoon after 12:30.
Okay, thank you. What might work well then actually is slightly unusual. I'm going to ask the council, depending on what they think about this, but we could have the evidence in chief from Mrs. James and then have lunch, and then before we start with cross-examination, hear from Mr. Jolly. That's slightly unusual, but I think it might work well in terms of time schedules.
I can speak before 12:30 if so wish.
Oh, you can do before as well, Mr. Jolly.
I can speak before 12:30 if that's what we prefer.
Well, if you can speak after Councillor Ogborn, then that would be helpful.
Okay.
I appreciate it. Thank you very much for being flexible. Thank you. Okay. Yes, Councillor Ogborn.
Okay, so I'm chair of parish council, and obviously speaking on behalf of the whole council here. As the council strongly opposes the appeal to reverse East Cambridgeshire District Council's refusal to grant planning permission for this retirement village and affordable homes. Obviously, our reasons for refusal were placed at length in our original response to the planning application. But I'd just like to add a few more additional thoughts on top of reiterating our key objections. Obviously, the impact on the green belt has been well covered already and referred to by East Cambridgeshire, and they have our full support on that. We don't see any very special circumstances to justify development on a unique area of green belt, recognised of significant landscape value and outside the village envelope. The claim that there is no other land available for this type of development anywhere else within the district, except on this unique area of greenbelt, we find highly questionable. Dr. Keith has made a very strong case with reflecting on the impact on the local community and the care of current residents. We would support that. We'd also add that with such a large increase in the elderly population, the age grouping within the village will be unbalanced and even more skewed than at present towards older age groups. The village will lose its broad population mix and become instead a place to die, to come and die. So we don't want that. Coming on to another aspect, which is the need for affordable homes. The council has always worked to provide affordable homes for residents, and we've supported a plan to build 50 homes off Bell Road, identified as Bot 1 in the ECDC local plan. This includes provision for a substantial number of affordable properties integrated within the whole development. This is now at the reserve matters stage, and I've actually just been out this morning and seen ploughing in the field where it's going in, and they've actually left half the field unploughed, obviously in preparation for work to begin. Supported by figures in the ECDC local plan, the parish council sees no quantifiable demand for any further affordable housing beyond this agreed development within the village. By contrast, a large concentrated arrangement of 51 affordable houses within one small corner of the proposed development would be unacceptable and contrary to national planning policy, which is that affordable homes should be integrated within a wider development. Comment has already been made about the conservation area, and we are very concerned that the access to the site is from the conservation area, and we want to see our conservation area preserved, and I know this will be reflected on further in further submissions. The size of the development in relation to the village will result in dramatically increased vehicle movements within the village. those of us who live in the village know that we've seen a massive increase in vehicle movements through the village in recent years, and often larger vehicles really struggle to negotiate the high street at peak times. The addition of well in excess of maybe 100, 200 vehicles coming in and out, we feel would create an unacceptable situation in terms of public safety, noise and pollution. A particular concern is that access to the proposed site is very close to our primary school, and we already have major parking issues around the primary school at drop-off and pick-up times. And we feel that having an access like this so close to it would significantly increase danger to small children. The appellant has referred to making a play area available in the retirement village. Obviously, any further play areas is always welcome, but we actually do have quite a lot of play facilities available in the village at Oxmeadow, at the primary school, and at Bottisham Village College. To this will shortly be added a play area in the new Bell Road development, which I've just referred to, and a natural recreation area will be established in a new cemetery, which we're going to establish along Road Road. As I say, it'll be always nice to have another play area, but it's not going to be a determining factor in our view of this development. The appellant has made reference to the improvement and offer of parkland for residents to walk in. We have to remember that we are already a rural village, which is why we want to preserve our green belt. We've got very large areas of open fields around us. I'm a very keen walker myself and walk miles every day around the footpaths around the village. We've got at least 8 footpaths all outlined on our website, so we actually don't need more parkland. So in conclusion, we feel that the current 2,100 residents of Bottisham will gain very little from this development, but will lose a great deal in terms of quality of life. And we would strongly urge that this appeal is refused on the basis of the above arguments. The appellant has failed to demonstrate the need for such a project that would justify the destruction of unique greenbelt outside of the village envelope, and also long recognised as of significant landscape value. Thank you.
Thank you. Just one quick question. The primary school play area, is that open to the public or is it just for pupils of the school?
It's open to the public outside of school hours.
Okay.
I often take my grandchildren there.
Thank you very much. Thank you. Now, I'll just turn to the other councillors from the parish because they said they may or may not wish to speak further to your comments. So this is your opportunity now. Okay, thank you. You've clearly covered everything. So thank you, councillor.
Should just say that there's no question, just for absolute completeness. I know you've sort of assumed it, but there was no questions from us at this stage.
Thank you, and thank you for interjecting. I should have been clearer about that.
I think John Wilson is wanting.
No, I was just going to say I have nothing to add. Councillor Ogborne and I had agreed a form of words for today's presentation, and I'm happy to go with that.
And I too support Sirs what the councillor has put forward, and there is just like to add, it is motive though, and not to put forward, but the village and the residents do have a strong feeling around this and around the retirement village proposal, and there are considerable objections that have been put forward, but people aren't really able to join into this Zoom meeting, but all of their comments have been obviously submitted online.
Yes, thank you. And yes, I will just confirm that now to everybody. I have read all the objections that have been submitted, and of course we'll be taking them on board in making my decision. Thank you, councillor.
Thank you, sir.
Okay, so if Mr. Jolly, if you are available now, then now would be a good time to hear from you. This time I will be say what I should have said the first time. And thank you, Mr. Simons, for reminding me. You're welcome to either allow for questions afterwards from the other advocates or not. It's completely up to you. So you can either just say what you want to say, and then that's it, or you can offer the opportunity for questions to be asked of you, and it's completely in your gift. So.
Okay, thank you very much. I'll use my allotted time to speak as a resident of Bottisham about the consequences as we see them of the proposed retirement village. I don't propose to dwell on policies or rules or generic infrastructure matters, as these elements will, I assume, be covered by others who also oppose the appeal. Can I start by saying it is not what it is, but where it is, which is the bedrock for our concerns. And I'm sorry, I must apologise now, because I'm sure I will venture into some kind of emotion. We have been residents of the High Street, just 50 metres away from the application site, for just shy of 30 years. During this time, we have seen the application site put forward on at least 3 occasions for development, using diverse mitigations in an attempt to override regulations. It should be noted that when the applicant acquired the land, it already had protected status. On each occasion, the application site has been opposed by residents and consequently rejected by both the District Council and the Parish Council in favour of less harmful sites elsewhere in Bottisham. The area I'm talking about has been described by the CPRE as being a meadow on grass chalkland and partly arable farmland that were once open parkland and heathland. The southern portion of the meadow is in the conservation area and contains a listed building and ancient earthworks of what is believed to be clay ovens. Maps of the village held by the District Council refer to this area as visually sensitive, and the inspector who recommended greenbelt protection referred to the area, and I quote, "the pleasant open countryside that flanks the eastern edge of the village beyond the bridleway east of Maple Close. The area is appropriately described as being of high landscape value, and the bridleway forms a clear-cut, permanent and easily recognisable boundary for the greenbelt in the neighbourhood." End of quotation. When I've walked along that path, I often have a piece of music in my mind, and perhaps members would like to listen to it at some stage. It's by Butterworth, and it's a rhapsody on a Shropshire lad, and it goes well with a nice walk around that particular area. What we can see from the High Street and from the public footpath is what remains of the locally valued and often visited part of the countryside. This and the pleasant open landscape beyond is the only part that remains unspoilt from the original bush meadow and parkland, thus vindicating its protected status. The application site's ecosystem supports an indispensable biodiversity in this epoch of climate change. The area has been used for animal husbandry for well over 200 years. It is visited by both young and old alike, including the local schools, to observe the plethora of wildlife that uses the area as its habitat. And within that, I include deer, badger, raptors. There is also the sheep that lamb there and also graze throughout the year. We are fearful that if construction is permitted, the lengthy access and service road to serve the residential part of the development, together with its street furniture and infrastructure, will cut a ruinous swathe through the meadow. This would result in this sensitive rural setting being disturbed and fragmented into smaller areas, which may then be too small for the indigenous plants and wildlife communities to remain viable, and for the biodiversity to retain and expand its contribution to the ecosystem. Moreover, traffic noise generated by staff, visitors, residents, and delivery vehicles all hours of the day and night, together with the street lighting along the lengthy access road, will adversely affect existing residential amenities. Likewise, the extra noise generated by the industrial machinery required to serve the day-to-day needs of the development, and being so close to existing properties, will further add to the loss of residential amenity. The proposed access road joins the High Street at a renowned speeding hotspot, with a sweeping bend coming from the east. I have over 10 years of Speedwatch knowledge in this area, and the data gathered by Speedwatch does not support the traffic data by the applicant, nor by the local highways authority. Parents park along this part of the high street daily at primary school drop-off and pick-up times, which add to existing road safety concerns. School buses and parents coming to and from the village college also contribute significantly to the traffic volume and speed along the high street at certain times of the day. Traffic wanting to leave or access the site would thus experience visibility problems that would add to the existing road safety fears. Furthermore, any person with any form of mobility issue would not be safe crossing the high street at this point to access, for example, the bus stops, due to the traffic speeds that often been measured in excess of 40 miles an hour, especially that traffic coming from the direction of the bend. We are mystified as to why these unallocated sites in the open countryside is yet again being put forward for development when there is already suitable land officially designated elsewhere in the village for affordable homes. In setting out their case, the applicant has not, in our opinion, provided sufficient evidence of a village need for either a further affordable homes or additional private residential care. The latter, according to Cambridgeshire County Council, can be met by existing residential care facilities in the village or by planned residential care new build elsewhere in the district within an acceptable travelling distance. Further retirement accommodation, in addition to the already substantial provision in Bottisham, may well trigger a harmful imbalance in the demographic of the village and will likely cause Bottisham to become the geriatric centre for East Cambridgeshire, with all the challenges and burden that this will place on the community and local services. Neither, in our opinion, has the applicant done sufficient to satisfy the requirements to consider development of brownfield sites or urban land closer to towns, new towns and cities. Sadly, it is the perception of many in this locality that the applicant had embarked upon a crusade over a number of years to have protected status removed. And to my final points, given the above comments, the application has not offered any acceptable justification in our mind for the very special circumstances required to vindicate this harmful development in this crucial and exceptional part of the village's green belt and conservation area. I would ask you, please, sir, to dismiss the appeal and thank you for your kind attention.
Thank you very much, Mr. Jolly. So simultaneously, I mean, are you willing to accept questions and do the appellant have any questions in any event?
I'm happy to accept questions.
Thanks.
Okay. Thank you very much, Mr. Jolly. Thank you very much for your time. Okay, so looking at the list of people to speak, we also have down to speak Robert Stocking, but he'll be contacting us to let us know his availability, and Councillor Kane, who I believe will be tomorrow at 9:30. And I'll just pause there to make sure that that's covered everything. Okay, thank you. In that case, it does look like we have time to go on to Mrs. James and her evidence in chief before lunch. So if I can just turn to the council now, please.
Yes, so if I can call the first witness, Mrs. James. Mrs. James, if you turn your camera on. Can you hear me, Mrs. James?
Yes, I can.
So we can see from your first paragraph that you hold a Master's in Urban and Regional Planning at Westminster University. You're a chartered member of the RTPI, and you're currently a planning consultant working for the District Council. Is that right?
Yes, that's correct.
And have you got your proof of evidence in front of you?
I have.
And you adopt that as your evidence to this inquiry?
I do.
Thank you. So it's not my practice to ask witnesses to read out parts of their proof, so I'll just dive in to some supplementary questions.
Okay.
First topic, Mrs. James, is HOU 6. And can we take up Mr. Warner's proof at page 10?
Yes.
Yes, so for T-Rock, so if we look at page 10 and 11, we can see that Mr. Warner accuses HOU6 of being inconsistent with national policy and goes on to say that he says it doesn't apply to this appeal. Can you get your response to that?
Just before you do that, please can we just use CD numbers as well, please, just to help make sure everyone is got the right documents in front of them.
Okay.
So I believe we're looking at CD 9.2 for Mr. Warner's proof.
Yes.
Thank you.
Yes, Ms. James.
Okay, I consider that the appellants are being slightly overly legalistic in the expression of residential care accommodation, and I would disagree, as within the explanatory text of this policy. If you'd like to take up CD 4.5, which is the East Cambridgeshire Local Plan.
Thank you.
There is a breakdown of
so
that
page, that's page 50.
Oh, sorry. Yeah.
Okay, thank you.
Okay, so there are several options where residents can enjoy their own self-contained homes within a site offering extra facilities. These include homes, villages, and extra care housing, where various levels of care and support are provided in the home. The key point is there is an identified need for such provision that is unlikely to be met within the built-up area. And it is this information that the applicants at the stage of determining the application fail to provide.
So if we go back to the policy, I think the appellant is alighting on the words residential care accommodation.
I'm so sorry to interrupt. I'm really sorry. Some of our team are struggling a little bit to hear Mr. Smythe's questions. It might just be us, in which case I'm really sorry to interrupt. But I
was actually about to interrupt myself to say that there's a slight, I'm not sure if echo is quite the right word, but there's a slight background noise when you speak, Mr. Smythe.
Yeah.
Perhaps we can just try to see if that can be resolved.
Yes, Miss James, do you want to turn your volume off when I'm speaking?
Okay.
Are you in the same room?
Yeah.
Okay, so shall I mute myself?
Yes, and I'll do the same.
You're right.
Fine. So the question is this: I think the Mr. Warner is focused on the first three words of the policy itself, residential care accommodation, and it's interpreting that narrowly in the sense it does not apply to the appeal. So what's your approach as to how one should interpret the policy with respect to the explanatory text?
Well, I would categorically deny that claim, and that the policy is fit for purpose. It does provide residential care accommodation. It's explicitly said in the explanatory text that retirement care accommodation, extra care housing is acceptable. Well, it is part of the exception criteria, and any application that that is considered by the council under this policy would cover the full remit of residential care accommodation, albeit a retirement care village or a care in the community facility. The list is endless. In actual fact, the list of C2 uses grows exponentially each year. And this policy would be able to fit all those criteria and categories.
Next topic is growth 2. Can we take up Mr. Warner's evidence, which is core document 9.2 on page 21?
Okay, so
wait.
Oh, sorry, I'm so sorry.
So if we look at page 21, we can see that in the table that Mr. Warner affords growth 2 full weight. And if we turn over the page to the chart on page 22, we can see that in Mr. Warner's view, the appeal conflicts with growth 2, but only in a limited way. can we take up growth 2, which is to core document 4.5?
If I could have a page number, please.
Yeah, page 25. And the question for you, Mrs. James, is what role or status do you see growth 2 playing in the development plan?
Well, it's the locational strategy. It is the #1 policy, which goes to the heart of the development plan. And it implements a cascade approach, i.e. If you can visualize the pyramid, at the top is the focused development within the growth areas of Ely, Littleport and Soham, with the next level being limited development within the development envelopes. And lastly, the exception criteria, which is outside of the development envelope. If it would assist you, sir, I can provide you with a rudimentary map of the district, which illustrates where Ely, Littleport and Soham lie in relationship to Bottisham. I don't know if that would assist the inquiry. I can share my screen.
Okay, yes, I can't see how that would harm, certainly. Yeah, please do so.
Okay, just forgive me while I try and share my screen. Okay, can you see the diagram in front of you? It just breaks down the various areas within the district. So can you see my cursor if I move it around?
Yes.
Okay, so here you have Littleport right at the top. That's one of our main growth areas. Just below that is Ely. And then just to the right of bottom right of that is Soham. So this is where growth 2 at the top of the pyramid focuses all its growth, because that's where the infrastructure, the services, the facilities are all going to be key, instrumental in accommodating the delivery of the development within the planned period. And if you would like to see at the very bottom on the left-hand side is Bottisham. And so that gives you a kind of breakdown of where this policy is delivering growth throughout the district, with it feeding through down to the villages where limited infill is acceptable. I'll stop sharing now, unless you would like me to keep it up for a little bit longer.
No, that's fine. Thank you.
Okay. I hope that's been of assistance anyway. So as my evidence, my proof of evidence is really and truly this site is in the wrong side, wrong end of the district, basically. Well, although it falls within some of the exception criteria, it's outside of the development envelope. And at a very early stage, the applicants or the appellants have failed to provide any evidence that this development could be provided within the built-up areas.
And if we take up your proof of evidence, it's core document 10.1. And your point about it being the wrong end of the district, it's paragraph 3.17. It might help, Mrs. James, if you could share your screen again to show.
Oh, I'm so sorry. Sorry. So I just need to find my proof because I've just closed it down now. Oh, can everyone see that, or are they still seeing?
Yes, I've got that.
Sorry, Mr. James, I wanted you to.
Sorry, did you want to?
Yes, so if you could screen share the diagram of the district.
Oh, I'm so
then
sorry.
I'm referring you to the.
Okay. So I was so sorry. I seem to have a technical problem now. I can't find it. Yeah. I think I've closed it down and then can't find it again. So do forgive me.
No problem, just take the time.
I haven't got it yet.
Is this taken from a specific page of the local plan, or is it from another source?
Well, it's in the local plan, but it's just easier if I, okay, so I've got it now. Sorry, I've got it. Okay, right. Can you see it now?
No.
No, okay. This is strange. It's the thing when you have so many things open on your clipboard that it's hard to get to the specific one, isn't it?
Well, it'd be easiest given that we do all have the plan ourselves, you know, the actual local plan itself. Maybe maybe a reference in the plan might be enough for us all to follow along if that was convenient. But obviously, if you know, if there's something particular about that drawing that needs to be shown, then fine.
It might also help just for my future note to know exactly what is in the local plan as well as the page number, so that when I want to refer back to it myself, I can find it.
Okay, we can email that to you. At the moment, I'm just having a bit of technical difficulty. Open. Okay, right. Now I've got that open now. I should be able to share that screen. I don't know why it isn't. I don't understand. It's actually on the screen. Is it because it's read only, do you think? I can't. Yeah, we just Googled it for ease of, let me, if I put it over there, would that be easier? For some reason it's not having any of it. Maybe if I close it down and try again. Oh, here we go. Yeah, that's a simple thing of closing an application down and then opening it up again. So do apologise for that.
Okay.
Now we're going to proofs of evidence.
So the question, Mr. James, is... Sorry, sir.
Sorry, I spoke over you, Mr. Smythe.
Don't worry. So, Mr. James, the question is, with reference to the screen you've now shared, and paragraph 3.17, what more would you like to say about the extent to which the appeal site is, quote unquote, at the wrong end of the district?
Well, just basically that it's well outside of our growth area, and will basically not contribute to growth within the Soham, Littleport and Ely. The degree of separation between them, it wouldn't meet with the catchment areas within those growth areas, and therefore unlikely to support the development there.
And in your proof, you make reference to Cambridge having a much larger concentration of younger people.
Well, absolutely.
So where's Cambridge on this map?
So Cambridge is sort of just outside of the screen on the right, the bottom right-hand side, where Kirtling, Brinkley, Borough Green So Cambridge would have, at the moment, has about 25% greenbelt land, whereas Bottisham only has 3%. Sorry?
So I think since Bottisham's got 3% greenbelt land.
Yes, Bottisham only benefits from 3% greenbelt land.
Sorry, Bottisham's a village.
Yes, the Bottisham village, well, no, sorry, the district, where Bottisham, Lode and Swaff and Bulbeck are located. There's only 3% of greenbelt land within the district located there.
Right.
When I was on site, I drove past Cambridge. I thought Cambridge was to the west of Bottisham, not to the southeast. No, it
is to the west. I'm getting.
It is to the west. Sorry,
to the southwest.
Yes, it is to the southwest. I do apologise. It's just the greater area is just it abuts that down to the south.
Okay, I'll say the council boundary goes further than the actual town itself, and it goes round to that corner. Is that what you're saying?
I think the area. So you've got to the east of this map is part of like Newmarket, Suffolk. Yeah. And so, yes, down to the southwest is the Cambridge Greenbelt area. Yeah.
The Cambridge Greenbelt area, I see.
Okay, thank you.
And just be clear what you're saying is, so your proof says that this district has 3% of its land area is covered in Greenbelt.
Yeah.
In South Cambridgeshire District Council, what proportion of the total land area is covered by Greenbelt?
It's 25% of the land area in Cambridge is Greenbelt land.
Cambridge City Council or South Cambridgeshire District
South
Council?
Cambridge.
Penultimate topic is the impact on the Greenbelt, and can we take up the latest inspector's decision on Bottisham at core document 5.14? Are you there, Mrs. James?
Yes, I am.
Yes. So we take up the decision. We can see it's by this inspector's namesake from October 2020, so about 16 months ago. And we can see that it is in relation to 4 proposed dwellings. And if we look in particular at paragraph 13, the inspector writes, by virtue of the overall scale, mass and positioning of the 4 dwellings within the appeal site, along with their associated garden areas, they would have an overtly urbanising effect on the area, thus harming its intrinsic semi-rural character and appearance. And in your proof of evidence, you identify that site with the appeal site. In your view, how proximate are the two?
Well, in my proof of evidence at 2.21, I provide a schematic, a drawing of our appeal site, which is edged in black, and then shaded orange is just below that. So that gives you a fair analysis of the location of the appeal site in relation to the dismissed appeal at land at 187 High Street, Bottisham, and that was just for 4 dwellings, whereas this development of 170 units plus affordable housing is incrementally more than the appeal decision that was dismissed for 4 due to openness, the impacts of the main issues identified were whether or not the proposal would be an appropriate development, the effect of the proposal on the openness of the Greenbelt, and the effect of the proposal on the character and appearance of the area. It was considered by the inspector that it was inappropriate by reason of inappropriateness and other harm, and would be clearly outweighed by other considerations so as to amount to the very special circumstances necessary to justify the proposal.
Anything else you want to say on this decision?
Well, if the inspector considered this is, consistency in decision making is an extremely integral part of planning, and if the inspector considered that 4 dwellings would have an adverse impact on the openness of the green belt, well, then surely it should follow that a development of this size and scale would be considered the same.
Final topic is the alternative sites assessment of the appellant.
So I'm going to stop sharing now, sorry. Okay.
So first question, was any alternative site evidence presented to the council at application stage?
No, there wasn't.
Second question, did the appellant make any contact with the council prior to serving the alternative sites evidence?
No, the first time we've seen this is a month ago.
Can we take up Mr. Belcher's proof? And the reference is 9.5, I think. Let me know when you're there, Mrs. James.
Oh, sorry. Yes, I am. I'm sorry.
Yeah. So we can see that Mr. Belcher applies 2 filters. So at paragraph 3.2, he has a size filter. So any sites less than 3.5 hectares are excluded, and any sites bigger than 7.5. And the second filter he applies is at paragraph 4.10. Where he finds that if a site wouldn't be ready for occupation within 3 years, it is excluded. So my question to you is, have you seen evidence to justify the extent of these 2 filters?
Well, the filters that Mr. Belcher has provided, when assessing the list, you'll find that on page 22 of 45. There are a number of sites that within the East Cambridgeshire district, which he's referred to, which are outside of that size criteria, that threshold size of 3.5 to 7.5, which a number of the sites in Soham, which is in the growth area,
I think we may be getting a bit confused. Do you want
sorry.
I think you're taking the inspector to Mr. Belcher's alternative site assessment, which is core document 9.6.
Yeah.
So do you want to give the inspector the page number so that he can follow what you're saying?
Okay. So I'm looking at page 22 of 45, where Mr. Belcher has provided a number of sites and they're color coded.
That doesn't quite cross. So my 9.5 has 59 pages and 9.6 is just a summary. Oh no, I see. Oh, you mean
it's the appendices. It's the appendices.
No. Thank you. I've worked it out. Thank you.
Sorry.
Okay, I'm there now. Thank you. Okay, thank you.
Okay, so the size assessment criteria he's used is 3.5 to 7.5. However, on page 22 of 45, there are a number of sites within Soham that have been discounted because they either fall outside of that threshold, I will take you to SOH1, SOHM 1.
So just so the inspector's clear, this is the column on the right side.
On the right-hand side, sorry.
Mhm.
So SOH1 is land off Brook Street, which is said to be 22 hectares and therefore excluded. What's your comment on that?
Well, we have a current application in for 11 hectares out of that 22, which is part of the housing allocation for the housing scheme of 400 dwellings. So it's only being brought, only a part of that site is being brought forward. And therefore that would leave another 11 hectares of land that would be available for development. Maybe a portion of that 11 hectares could be used for the appeal site because, or the appeal development, because that needs at the very most 7.5 hectares.
Then the next site is SOH3 in Soham, which is described as the Eastern Gateway, which Mr. Belcher says is 33 hectares in size and is therefore excluded.
Okay.
What's your comment on that?
Well, we have an outline application for a development, a mixed-use development, which would take 23 hectares. So again, that would leave 10 hectares of available land for use as a C2. It's the housing, well, the housing threshold on that site would be up to 600 houses, and we would not distinguish between C3 or C2, and therefore the C2 use of 170 dwellings or units would be acceptable on that site. However, the appellants have failed to provide or have come in for any pre-application other than the appeal site in Bottisham. They have failed to come in for any pre-app advice on any of the other sites. Soham, as you know, is within their market catchment area, and it's within our growth area. So it does seem the likely area that we would try and focus development, where it would be within the criteria of our growth 2, which supports growth within those within Soham. It would be within the development envelope, and it would have an access to a range of facilities, services, and infrastructure commensurate with the growth area.
And then the final site I think you wanted to address the inspector on is SOH6, which is described as land north of Blackberry Lane, which Mr. Belcher says is 4.4 hectares in size. Have you got a comment on that?
Well, that would be a perfect location for this, for a development, the retirement village, because it's within the site criteria. The site to the south of Blackberry Lane is being, well, it's under construction. It might actually be occupied. It's been allocated in our local plan for development of up to 100 houses. Again, we don't distinguish between C3 or C2, so we would look positively on a scheme, and in view of the acute need for this type of housing, which would also contribute to the 5-year land supply. But again, no advice, no pre-application advice has been received. So it's disappointing, to say the very least, really, that that the applicants have, the appellants have chosen to develop the greenbelt, the very sort of precious commodity that we have within East Cambs, in light of the fact that Bottisham has already released land for housing. That there was no pre-application advice or any sort of any interaction with the appellants as to why they've chosen this site out of any others. In actual fact, we've only had this document for just under a month, and really and truly we could have dealt with this possibly at the pre-application stage and helped the applicants and considerably in providing this valuable type of accommodation. There is another site which I think was mentioned in Mr. Warner's evidence about a site in Dullingham.
So the inspector's note, that was paragraph 8A of my opening, which is the site east of Clare House Stables in Dullingham. That's the outline planning permission which lapses in a fortnight. What do you want to say about that, which is in addition to what the inspector can read at paragraph 8A of the opening?
Well, only that there is provision for a variety of uses on there, especially it's within the site criteria. It's 5.67 hectares. You've got ample opportunity to provide open space. You've got plenty of room to put your community uses on and your residential care accommodation, your retirement village. It lapses, as Mr. Smythe has said, that it lapses on the 5th of February, actually, which is a real shame that the site hasn't come through, hasn't come forward for development. And it's outside of it's not in the green belt. So it would be, we would be sort of looking at that site with, well, we would like to maybe discuss that with the applicants, had we had the opportunity.
And the other site mentioned in the opening is paragraph 8B, which is the site described at Station Gateway, Angel Drove in Ely.
Yes, that's...
anything more you want to say in addition to what was said on the council's behalf?
Well, again, well, again, this site in Ely has been vacant. A lot of the area is ready for development, basically, and it would be suitable for a mix of uses. A retirement care village would be an acceptable asset to Ely, as Mr. Simons has said, that there hasn't been, apart from one development in Lyle Lane, there hasn't been a retirement village or retirement facility that, you know, providing extra care in Ely, and you know, we would look favourably on this type of accommodation coming forward on part of this site. It's large enough to accommodate a development of that size and scale, and as I've said before, it would be an asset to Ely.
And given that Mr. Belcher has missed the Clare House Stables in Dullingham site and the Gateway site in Ely, what confidence can the inspector have that the assessment is as thorough and robust as the appellant suggests?
Sorry to interrupt, and I don't mean to, but that was obviously that was a leading question because he hasn't missed them. But I'd prefer if it could be put in a less leading way, because it's not the only reason I intervene is because that's not a sort of an agreed proposition, as we'll find out in cross-examination once we read what's in the ASA. But so if it could be just, I don't mind the question being asked, if it could be put in a slightly less leading way, I'd appreciate it.
So I'm happy. I mean, I don't think it was a leading question. The question was, what confidence can the inspector have?
You said, given that a couple of sites have been omitted from the ASA, which is a proposition that you're making. Okay, fine. You ask it.
Yeah. Mr. Simons, you obviously have a chance to come back on this in cross-examination. So
Sure, of course.
So my response to that is that, in view of the limited amount of time that the council have had to consider Mr. Belcher's alternative site assessment, I'm sure that there would have been an opportunity, had this been done earlier on in the stage, the planning stage, that we could have identified sites together, and as any council that is proactive in trying to enable development, especially this much needed extra care. As I say, I'd reiterate that it's extremely disappointing that we've not actually been able to help in making some of these sites within our growth areas available to for them to consider and it would just cast doubt on the whole process that they've undertaken, which I'm led to believe it was undertaken in the latter part of last year. And now the application was submitted in 2020, and now we are in the beginning of 2022, where it's a lot of lost time. As Mr. Smythe was mentioning earlier, that they're looking for a 3-year time horizon, and therefore this prohibits some of the other sites that Mr. Belch has put forward in coming forward. However, already 2 years have been wasted basically in being able to work with the applicants and trying to realise a very important development. To my mind, the applicants or the appellants aren't actually extra care housing providers. They're rather like land assemblers, and it's still not known whether there is a purchaser for this site, as the appellants would still need to market the site or the development should the inspector consider allowing the appeal. So it does cast doubt on the scope and nature of the filter that was used on producing this alternative site assessment, and the 3-year time horizon that's been provided. That's all I have to say on that.
Thank you. Then the final topic is just to pick up a issue raised by the inspector earlier this morning, and the apparent inconsistency between different paragraphs of the Statement of Common Ground in respect of heritage. Can we take up the appellant's heritage assessment, which is core document 1.4? Let me know when you're there, Mrs. James.
Sorry, core document for CD, what was it again? Sorry.
1.4.
1.4. And that's the built heritage assessment, isn't it?
Yes. So my question to you is, does the council accept or reject the appellant's built heritage assessment?
Well, in referring to page 44 to 48, the council agrees with the appellants that heritage assessment that the proposed development has the potential to impact on the significance of the conservation area through the change to its setting, and the degree of harm would, however, be a planning judgment.
Is it the council's case that the impact is unacceptable?
I think it would need to be tempered, considering the impact on the conservation area. I'm just getting to that section, actually, page 47, sorry. So yes, the degree of harm would need to be weighed against the wider public benefits of the scheme.
But the council agreed that there is less than substantial harm.
Yes.
Okay.
Mrs. James, that's all the questions I have for you. Is there anything else you wanted to say?
No, thank you.
If you wait there, no doubt after we return to lunch, Milena Friend may have some questions for you.
Okay, thank you.
Thank you very much, Mrs. James. Yes, so obviously up next is a cross-examination by the appellant. If I could turn to Mr. Simons, it does seem like an appropriate time to have lunch and then come back.
Absolutely. So yeah, certainly, yeah. If that suits everyone else, that works for us.
Okay, so since we have an hour and start again at 1:30.
Are we expecting more? I've lost track, sir. Have all the members of the public who were planning on saying something? Is there someone else to interpose, or is it just me on after lunch?
No, it's just you, because Mr. Stocking is the next person, but we don't yet know when. Right. And Councillor Kane is tomorrow in the morning.
Got it. Lovely. Well, that's good news, sir. And also, with an eye, my estimate was up to 3 hours. So, with an eye on your point, sir, about not overrunning, we'll see obviously how we get on. I'd hope to be able to finish, Miss James, today. I mean, maybe, sir. I don't know if you felt like doing a slightly, maybe a sort of a 50-minute lunch break or something like that, just to sort of make sure that we can try and get Miss James done today, if at all possible, and finish at say 4:30 or something like that, rather than sort of having her in Purda overnight, which I'm sure wouldn't be ideal for Mr. Smythe or for Miss James. But anyway, I'm happy to see how we go.
Yes, I think I agree. We should try to have finish Mrs. James's cross-examination this afternoon, which probably means 2 sessions this afternoon, which I think that makes sense on the first day. We're still fresh, and it just makes sense in terms of overall flow.
I'm very happy with a shorter lunch break.
Okay, so we can have a 45-minute lunch break.
Right.
And that will help that to occur.
Right.
So I also, because we haven't yet started cross-examination, you're not yet in Purda, Mrs. James.
Okay, thank you.
That's helpful for you as well. So yes, if we break now and resume at 1:15.
Thank you very much, sir.
Okay, thank you. The inquiry is adjourned.
Sorry?
You're not muted, Miss James, yet, just so you.